Meeting is being recorded.
I'm going to call the meeting of the Sentencing Guidelines Commission to order. Today is Thursday, March 10th, 2022. We are located in the Afton room at the Department of Corrections facility. So thanks, Commissioner, for allowing us to use the room. Let's go ahead and get started. We'll do the roll call, get through the first couple of items, and then get into it.
Thank you, Madam Chair. I just have an announcement before the roll call, and that is that Commissioner Blakey has accepted an appointment as the Director of St. Paul's new Office of Neighborhood Safety. In that position, she will no longer be a peace officer, and she is thus no longer eligible for membership in the peace officer seat on the Minnesota Sentencing Guidelines Commission. So she resigned from the Minnesota Sentencing Guidelines Commission effective Tuesday. So I will not be calling Commissioner Blakey's name on the roll. Assuming I remember that. Roll call, Vice Chair Estrada.
Present.
Estrada present. Hansi.
Present.
Hansi present. Knudsen.
Present.
Present. Ladd.
Present.
Ladd present. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Schnell.
Present.
Schnell present. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 10 members present, 1 seat vacant.
All right, thank you. I just want to correct the record. It's a hybrid meeting today. I had said we were all here in person. About half of the commission is here in person, about half is online after we gave appropriate notice for the hybrid meeting. First item is approval of the agenda. So I'd entertain a motion to approve the agenda.
So moved.
Commissioner Schnell makes the motion. Do we have a second? Commissioner Middlebrook seconds. Any discussion on the agenda? All right, hearing none. Nate, if you could take us through that.
To the Schnell motion to approve the agenda, Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
All right, with that, the agenda is approved unanimously. Next item is approval of the draft meeting minutes from February 10th, 2022. I'd entertain a motion to approve the minutes.
So moved.
Commissioner Moore makes the motion. Do we have a second?
Second.
Commissioner Knudsen, seconds. Any discussion? All right, hearing none. Nate, please go through the roll on that.
To the Moore motion to approve the minutes, Estrada?
Yes.
Estrada, yes. Blake, Hansi?
Yes.
Hansi, yes. Knudsen?
Yes.
Yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
All right, and with that, the minutes are approved unanimously. Okay, so the next item on the agenda is the sex trafficking review. The staff has prepared some information for us on current sentencing practices as we had asked at our last meeting. So I will turn that over to Nate and the staff to run us through that.
Thank you, Madam Chair. So we presented to you an information paper that just gives you some overview information on sex trafficking and prostitution sentencing practices. Generally, 2020 data are omitted here. We do have 2020 data, but as we've discussed previously, we don't consider those data to be typical, and so we're generally omitting them. You can see the volume of sex trafficking cases here is pretty limited. It's an average of 6.6 first-degree sex trafficking cases each year, 18.4 second-degree sex trafficking cases, and then one or two aggravated first-degree and second-degree cases, respectively. And then we were looking at prostitution offenses on the standard grid. You recall this was outside of the legislative mandate to study. The number of cases where the child is under the age of 13 or reasonably believed to be under the age of 13, very small, average of well, only one during the time period that we were looking at, so much less than one per year. The age 13 to 15 are reasonably believed to be age 13 to 15, significantly higher. 32 of those, 2 were presumptive commits. So that's ranked at, I should say the first offense is ranked at severity level 9, where all offenses are presumed commit. The second offense, 13 to 15, is ranked at severity level 5. And we can get it more into like what these cases are specifically about, but typically these are in many cases sting, and there's not actually a real child involved. It's rather law enforcement posing as a child, and when the defendant walks into the trap, I guess I shouldn't use the word trap because that implies entrapment perhaps, but when the defendant takes the bait, then the defendant's arrested. So that's the 13 to 15. That's now, I should point out, this is all under the old law where the cutoff was 13. That cutoff has now been raised a year. So under current law, that wouldn't apply. That would be just 14 and 15-year-olds. So I guess it's really a question of, in most cases, what age the officers are going to pose as in trying to entice the defendants. Only 2 presumptive commits in that case for that offense. And then 16 or 17, I should say, not 16 or 18, but and that had a similar numbers as far as case sentencing. There were only 4 presumptive commits out of those 139 cases. A total of 7 presumptive commits for these prostitution offenses on the standard grid. There's now a new offense that's on the standard grid. I guess I would just say regular adult prostitution now is a felony if it's a repeated offense. And that's not included in the data because it's too new. Table 3 shows you the demographic information on these. You can see that there are distinctive profiles, I would say, different demographic profiles. This generally tends to be, prostitution offenses, you can see it's clearly overwhelmingly male, not any females during the time period that we were looking at, which is pretty striking. I mean, that generally tends to be true of sex offenses in general, but definitely very high for prostitution offenses. For sex trafficking offenses, you can see that the percentage of defendants who are Black is significantly higher than in the other categories. Whereas for prostitution offenses, the number who are white is higher than the other categories. And then figure 1 shows that graphically. You can see you can see how there's not uniform distribution of racial groups among these 4 different categories. I think it particularly pops out in the sex trafficking. The green bar, which represents Black defendants, is significantly larger in that category than in the other categories. Figure 2 graphically shows that distribution by judicial district. And what at least pops out to me here is the 4th judicial district has a larger share of sex trafficking cases than it does have of other cases, as well as prostitution cases. And you can also see, I believe that's the 7th judicial district that sticks out on the sex trafficking significantly more than its share in the other categories. Moving on to prison rates, in table 4, that shows us the number of prison sentences and the prison rate, the rate at which people are receiving prison sentences. So there's a pretty high imprisonment rate for sex trafficking, significantly lower imprisonment rate for prostitution offenses. Table 5 is looking at departures. The aggravated durational departures tend to be small. Mitigated durational departures, we do see fairly high mitigated durational departure rate, a little bit lower mitigated dispositional departure rate. And that's it for the data. So any questions or comments about the data?
Yeah, that's a lot of data.
It definitely is. Does anything stick out to anybody? It looks like Commissioner Larkin, you have your hand up.
Nate, could you maybe remind us what exactly we've been asked to look at and perhaps do so we have some context for this data? I know you've explained it before, but if you could just highlight the instructions from the legislature, that might be helpful.
Well, it's to review and to consider modifying how the sentencing guidelines and the sex offender grid treat sex trafficking offenses. What we're calling sex trafficking offenses, the offenses under 609.322. I believe it's comprehensively review.
Yeah, I was just going to say, I think
Yeah.
the language is comprehensively review, right?
Any idea of what they might be hinting at? And it's sort of a broad instruction, right? I'm just struggling with what it is they might want us to do. What should we be looking for?
Well, we kind of got into that. I'd kind of like to invite the Stearns County Attorney's Office in to talk a little bit about what they had in mind when they were asking for that, because they were the proponents of the legislation. They essentially authored it. And we talked a little bit about that last time. It seemed like in the testimony of Ole Tweeden, the criminal division head, that it seemed like most of what they wanted to have happen would happen automatically, or not automatically, but naturally by action, by the commission's natural reaction to these laws when they were passed. And when I say these laws, I'm referring to all the changes that were made to sex trafficking last summer. The commission responded to those, fiddled with the grids a little bit in some cases, just basically to accommodate these new higher statutory maximums. So that seemed to be part of what they wanted to accomplish. The other thing that at least that task force wanted the commission to consider was ranking aggravated sex trafficking at a higher severity level. Right now, aggravated sex trafficking is not ranked as a specific offense. Instead, it's a modifier. So it'll either modify first degree or second degree and add more time to first degree or second degree. What the proponents were suggesting is that the commission consider, instead of modifying the punishment, to actually just rank it as a separate offense at I believe severity level A is what they were hoping for. So that would be one approach. And you can see aggravated cases don't really come along that often. So I think we could definitely spend some time looking at these aggravated sex trafficking cases and see if, what happened according to the story in the criminal complaint, and how did the sentence work in terms of the sentencing guidelines, and was that appropriate in that particular case? So that would be one approach that the commission might consider taking, Madam Chair. Does that answer your question, Judge Larkin?
Yeah, that's very helpful. Yeah, because it's sort of a broad instruction to just like comprehensively study something without any guidance as to what the proponents might want is not necessarily helpful. So it seems like that's something concrete we could look at. We've got unranked offenses. Should they be ranked? And if so, should they be ranked as the proponents suggest? And that's one approach.
And I don't mean to mislead Madam Chair and Judge Larkin. It's not precisely that these offenses aren't ranked. It's that the base offenses are ranked, and then there's a modifier for aggravated offenses. So the guidelines have a scheme right now for these offenses. It's just not that they're separately ranked. Instead, it's the base offenses ranked plus a modifier, as opposed to just ranking it as at A, which would be a more severe punishment.
So I guess then if that's possibility, what I'd want to see is, all right, well, what are the offenses where this modifier applies and what sentence results, and how does that number compare to the number that would result if we were to get rid of the modifier and just rank the enhanced offense and then take a look at the conduct that underlies those types of sentences. Does that make sense? I'm just trying to figure out a strategy to address this instead of simply saying, hey, what does anybody think of all this? I mean, it seems like we need some sort of direction.
And Madam Chair, if that is something that the Commission's focusing on, and I think that's reasonable in light of what the proponents were saying, there were only 13 cases sentenced over a 6-year time period. So I think we have the luxury with a case volume that small to look at individual cases and say, okay, what happened? What was the presumptive sentence? What was the actual sentence? What were the prosecutors requesting? Those sort of things.
Yeah, I actually had the same thought in my notes that we should look at what would it look like to change the sentencing scheme from the way we have it now to ranking it the way that the folks who brought the bill forward requested. It's not necessarily with the legislature. They haven't directed us to do anything, but that's what the folks who were bringing the bill forward thought was important. So I think it's worth it to do that. I do want to point out, though, interestingly enough, that just the data in front of us shows that that most of these aggravated sentences don't seem to be getting the full sentence available to them now. So I'm actually very curious to see what the difference in those numbers would be, because if it's a lot higher, then I think that the likelihood that those sentences would end up being imposed would be pretty small based on past practice. But I think we should get those numbers and see what it looks like. Any other comments, questions?
I guess as we go into that, could we, because I didn't really follow that, those changes, those legislative changes, if we could get a copy of what was actually changed in that session where they're asking us to take a look at, so we could get a better idea of what the differences are and what they might be aiming at for us to focus on.
Well, we did go over that at the last meeting. I'm sure we could go through some of that again.
Yeah, I suppose I can relook at the minutes, but I just haven't really focused on what those actual changes were, and then in conjunction with what recommendations we might make for any guideline changes.
I mean, if I may, Madam Chair, in a nutshell, the changes were really of two kinds. One was they raised the statutory maximums for the sex trafficking offenses, which in most of the cases simply caused it to fit in the grid. What happened was the grid time was actually longer than the statutory maximum, which is not typical. So that the prosecutors were complaining that in some of these cases where people had lengthy criminal histories, that they weren't getting the full grid time because of the statutory maximum. So my recollection is in at least 2 of the 3 cases, that increase in the statutory maximum caused the grid and the stat max to be in harmony. The other change had to do with the prostitution offenses, which was changing the age threshold from 13 to 14, which is part of really a larger legislative movement to do that. They've now changed the threshold from 13 to 14 in criminal sexual conduct offenses, child pornography offenses, and sex trafficking offenses. So that's really, although there's still one technical area that they missed in prostitution offenses, and they tell me they're going to fix that as soon as they pass another bill. But they just missed it on one of the entries. But otherwise, it's now in harmony.
And so I want to point out that we've actually looked at these things a couple of times already. So one, that all of that legislation was passed last year, and we went through it as we had to decide ranking decisions in the summer. So we did make initial decisions then, and then the direction to us was also to take a deeper dive. So that's what we're doing now. It's essentially going back to say, okay, we've already made ranking decisions on these offenses. If we take a deeper dive and look further, is there anything that would cause us to change those decisions? And so that's the process that we're engaged in now. When we do initial rankings, we don't often have the luxury of time to get this deep into the weeds to reconsider things. So that's what we're trying to do now. Commissioner Middlebrook, you had your hand up earlier.
Thank you, Madam Chair. I was just going to answer his question about the last month. There was, in the PowerPoint, there was a couple of slides that were really helpful on what those changes were.
Right. Yep. And I think that's linked in the materials from today as well. I would like to, when I looked at the sex trafficking data, the things that really jumped out to me were, number one, that the majority of these cases are ranked at a location where prison is the presumptive sentence in the majority of these cases, not the prostitution cases, but sex trafficking. And about 3/4 to 4/5 of those cases actually receive a prison sentence. So they're mostly aligning with the guidelines in that way, but there's also a large proportion that receive a durational departure. So they're getting prison, but for less time than the guidelines call for. So I think that tells us that there is something about the factual circumstances of these cases that might make it difficult to take it up further. That's just, one thing I see initially. But that being said, I do want to explore this idea of ranking the aggravated first degree offense at A versus having the 4-year enhancement, just to see what's the difference in those sentences. Because if that's, I think we should take a look at that, especially if that was a point a point that the folks who brought the bill were interested in exploring. So I think we should do that. And I guess the question would be, what other things is the commission interested in looking at for this particular topic? Are there other things that come to mind as you look at the data and we've talked about these issues today?
Madam Chair,
Commissioner Knudsen?
thank you. The data that is provided later on here on the custody status with respect to failure to register offenses, I think is worth looking at in this context specifically.
Could you explain that further? They're not really the same offense, so I'm not following you, I'm sorry.
Well, sex offenses, it's not the trafficking and all that or prostitution, but it's the sex offense issues. If you think that that's all related, any relation to any of this, so.
Well, I think if you're able to come up with a specific question to put to the staff to look into, like we could definitely do that. I'm just not sure what it would be related to sex trafficking right now only. That's all I'm talking about right now.
All right. Thank you.
Okay. Any other? Oh, Commissioner Moore.
Madam Chair, and maybe Director Wrights, is there a process that the commission has used to determine which offenses should be classified as severe violent offenses? I mean, or is that kind of on a case-by-case basis? Because it seems like that's one of the potential issues for discussion here as I see it.
Madam Chair, Justice Moore, so the severe violent offenses were created as part of a compromise package that was a consensus-based package. It was agreed to unanimously by the commission, and it had some provisions that were more lenient and some provisions that were more severe. And this repeat severe violent offender provision was the primary provision that was more severe. I don't know that the rationale for what should be included in the repeat severe violent offender provision was very well articulated at that time. It was mostly what the people who were my recollection is it was mostly what the people, this was 2018, and it was mostly what the people who were really interested in that particular policy wanted on the list.
So is that, Commissioner Moore, you're absolutely right that when we ranked these offenses, the one thing we left on the table was whether we should add them to the severe violent offense list. So I assume that you're asking about what do we need to do to consider that, right?
You articulated it more eloquently than I did. That's exactly what I was trying to get at, because it seems like that's, and I support the thought of hearing from the bill proponents at some point. That might be helpful, but rather than speculating as to what changes they might like to see, I'm wondering if this might be one of them and what things we should think about in considering whether that's appropriate. I don't have a personal opinion on that. I haven't studied it closely enough.
And I should say that was one of the changes that I believe occurred last summer that I omitted when I was describing the changes, was they added sex trafficking to the statutory list of violent offenses in 609.1095, if I'm recalling correctly. And I think I raised it to the commission last summer, and I think you were just alluding to this, Madam Chair. Does the commission want to consider sort of following suit, if you will, and adding it to the commission's list of severe violent offenses? Now, I mean, it does seem that the commission's list of severe violent offenses is a little more choosy than the legislature's list of violent offenses. The legislature has multiple violent offense lists, if I may be candid, but this particular one in 609.1095, is a little more broad spectrum than the commission's list of of severe violent offenses in Section 8 of the guidelines. But I guess considering the fact that the commission has labor trafficking on that list, but does not have sex trafficking on the list, it seemed like an appropriate time to visit the question of is this something the commission wants to have on the severe violent offense list, or at least aggravated. If you're looking at violence, you can look at some of those aggravating circumstances, and some of them tend to involve violence. So maybe not all of them, but you're certainly getting there, it would seem.
And if I recall correctly, the reason that the commission delayed that decision a little bit was because we didn't have real clarity on what drove when things should be added to the list or not, because there wasn't a clear sort of sense of direction left by the commission that created that list. So it seems like that is a topic that we should also take up, is just to look at the severe violent offender list and really, come to some agreement on when should an offense be on it versus off it, or what factors. Like we have particular factors that help us rank offenses. I think it would be helpful to have factors that help us decide whether something's appropriate to put on the severe violent offender list as well.
Madam Chair, and I should also say, Madam Chair and Justice Moore, there is a comment, I think maybe a couple of comments pertaining to the severe violent offender policy. Those comments I don't find particularly helpful in determining what should be on the severe violent offense list. It's more explaining why the commission felt it was necessary to establish the severe violent offender the repeat severe violent offender policy. But it would be, I think, appropriate if the commission wanted to do that, to articulate, sort of what is Section 8? What do we think are the criteria for putting something on the severe violent offense list? It would be appropriate, I think, to add another comment, perhaps, explaining that for the benefit of the future commission members.
Okay, so I think I'm hearing three things. Number one, I'm hearing interest in having the folks who brought this idea forward to the legislature, to invite them to come and talk to us about what they may have been seeking when seeking legislation. I'm also hearing that we want to take a look at what's the effect of considering ranking aggravated first degree at 8 instead of having the 4-year enhancement. And then I'm also hearing that we want to look at the severe violent offense list and talk a bit more about what sorts of things should go on it on a regular basis, and then that will give us a stronger grounding for taking up that consideration again as to whether these offenses should be on that list as well. Anything else, Commissioner Middlebrook?
Thank you, Madam Chair. Could we also get the information on the aggravated departures and the mitigated departures, if we can get the reasons for those?
Specifically for the
sex
13 aggravated sex trafficking, are we mostly focused on that, or?
I guess I would be interested in all of them, just to see what the reasons are.
Okay. All right, did we cover the bases there? Anything else to talk about? All right, you have to bear with me. It's hard for me to get used to like a new perspective. I'm trying to make sure I'm looking out in the right places to make sure I'm seeing if somebody wanted to speak up about a particular topic. Okay, all right, I think we have a plan for what a couple of next steps on the sex trafficking review. So that's great. Thank you very much. All right, we'll move on to item 5, which is the custody status policy discussion, and we'll start with data presentation on that one.
I just unmuted my microphone. Can those attending remotely hear us at this point? Could you hear us just a minute ago when we were talking about taking a break? Okay,
No,
so
no.
we seem to have lost connectivity with the room, so we're going to take a little bit of a break. And so just please stand by, maybe 5-minute break. We'll be right back with you, hopefully.
Okay,
Thank you.
thanks.
All right, for those listening remotely, can you hear us?
I can hear you. This is Kyra.
Okay, outstanding. I think we're back. All right.
Thanks for your patience, everyone.
Can we resume the meeting, Madam Chair?
Yes, let's please resume the meeting.
Great. I'm going to try to share again. I hope I didn't cut off. Looks like we're still good. Okay, so this is a staff information paper called "Who Receives Custody Status." This is limited to cases sentenced in 2019. And basically, we're looking at of all the people sentenced in 2019, about half of them, 48%, had a custody status point of some sort. So who were they? So table 1 is looking at the distribution on the standard grid by severity level. So looking at severity level, what was the distribution of what percent had custody status? Keeping in mind, so on the standard grid, the total was 47%, so a little bit lower than overall, not too much lower. And you can see that the two levels that really jumped above that average were at severity level 4 and severity level 7. Severity level 4 has a lot of person offenses on it. It's a pretty popular severity level for that reason. And severity level 7 has a lot of the DWI offenses on it. So those are the two severity levels where more than half had custody status. All the others were below half and also below the 47% average for that. Table 2 is another way of looking at the custody status distribution on the standard grid. And this is looking at each grid cell, how many people, how many cases sentenced on that grid cell had a custody status point. And in this case, and this is before the half point issue. So we're just looking at custody status. Well, I guess there might have been some cases with the half point in 2019. We showed you a very similar chart to this last fall when we were looking at custody status. This has the numbers in it. The shading might be a little bit different because I believe that was looking at 2 years worth of data. This whole paper is just focused on 2019, so it's just looking at 1 year of data. And you can see that severity level 4, how more of the custody status is found in severity level 4, and quite a few in severity level 2 as well. So this is the hot squares that we showed you before, but this time with the numbers in it. Next, we look at the sex offender grid. So for the sex offender grid, the total is almost 30% have the custody status point. And there's 2 severity levels that go above that, severity level F and severity level H. And in 2019, severity level H was solely reserved for failure to register as a predatory offender. So that was the only severity level that more than half had a custody status point. One thing that we aren't breaking out here is the special 2-point treatment for repeat sex offenders. So we're really losing a little bit of information here by lumping 1 point and 2 points together. So it doesn't show on here whether or not they're repeat sex offenders or whether the custody status was for a sex offense, which would give them 2 points, or not, which would give them 1 custody status point.
Isn't that what the last column is the?
Oh yeah,
points?
I'm sorry, that does show it. I missed that. Thank you. Yeah, so a very small number of those cases actually have the 2 custody status points. Thank you, I missed that. So a total of 16 out of the 1,130 cases total had the 2 custody status points. If you just look at the sex offenses not counting failure to register as a predatory offender, the percentage jumps down from almost 30% to a little under 17%. So non-failure to register sex offenses are, you don't see the custody status point that often. And then table 4 is again showing the hot squares distribution of custody status. And you can see graphically that most of the custody status is found at severity level H, which at that time severity level H was reserved for failure to register as a predatory offender. Then finally, the drug offender grid. So the average for the drug offender grid was 48%. And you can see that there are a number of severity levels that are higher than 48%, a number that are lower. And then the hot squares, again, you can see the bulk of these cases are at severity level D2, which is where controlled substance crime in the 5th degree is located. Next, we move on to custody status by offense type. So breaking them down by offense type, again, this is sort of what we've already, you could infer this from what we've already seen. Again, the average is 48%. Above that, you see the DWIs have a higher percentage than that. Drugs have a higher percentage than that. And the other, and weapons is just about at that average, a little bit higher. Other is a little bit higher. But the person and property offenses and those are a little bit lower than 48%. Next, we look at the custody status point by sentencing guidelines grid zone. So there's if you recall from other presentations that we've had there, you can think of the sentencing guidelines as divided in 3 different zones. Those are people who are presumptive commits based on the severity of the offense. In other words, regardless of criminal history, an offense that severe would be presumed to go to prison. People who are presumptive commits based on the criminal history score, which is to say, if you were a first-time offender, you wouldn't be going to prison on this offense, but because of this particular offender's criminal history, prison is recommended. And then mandatory minimum is the 3rd category. where it would be a presumptive stay under, as far as where it's at, where the case is at in the grid, but because of a policy, typically a legislative policy, it's a presumptive commit. And then the fourth category would be offenses that are not presumptive commits at all, but are presumptive stays. And you can see that perhaps not surprisingly, the history section is the section with the most representation by custody status point. So 70% overall are in the history section compared to 48%. I'm sorry, 70% of the offenders who are presumptive commits because of their criminal history have custody status point compared to 48% of offenders overall. And then next we look at the custody status point and the severe violent offense list. So only 2.7% of offenses sentenced in 2019 were severe violent offenses. They're all ranked at or above severity level 6. 33.4% had a custody status point. And 2 of the cases had 2 custody status points. So of the 159 cases with custody status point, they represent less than a percentage point of the 8,320 cases with a custody status, 0.2%. Of the 159 with a custody status point, only 56 had a true prior violent offense. And by true prior, what we mean by that is that before they committed the current offense, they had previously committed another violent offense. So we bring this up because there was some discussion during the public comments about repeat violent offenders getting a break by eliminating the custody status point. And this, I think, does display to some extent the magnitude of that effect. With respect to sex offenses, not including failure to register, 16.7% had a custody status point. Of those, 14 had 2 custody status points, which means that they were committing an offense with a previous sex offense. "17 had a true prior criminal sexual conduct offense. And I'm assuming there's quite a bit of overlap there between those 17 and the 14 who had 2 custody status points. All right, Table 9 attempts to show, to sort of link the custody status by their offense type and the type of true prior in criminal history. Doesn't necessarily represent the custody offense. We don't necessarily know what the custody offense was. We just don't have good data on that as far as how we capture data. But this does, we did look at offenses and try to determine. So this is among those offenses that had custody status, how many of them had a true prior, and of those true priors, and we're defining true priors in our own special way. What we mean by true priors is it's not a legal term, and we've gotten but what we mean by true priors is that prior to the offense date of the current offense, there was a previous conviction for one of the named offenses here. So of people with custody status, you can see that there's a definite correlation here, but not a perfect correlation between people who commit person offenses having a true prior person offense, if they had a custody status offense, people who commit property offenses having a true prior property offense, people who commit drug offenses having a true prior drug offense, CSC, criminal sexual conduct, not so much. And then, I mean, it kind of drops off a bit. But there are some interesting correlations there. All right. And then we have, in the appendixes, we have this severe violent offense list. And Appendix 2 is a list of felony offenses by category. So this shows you, when we're talking about person offenses, what do we mean? And this is essentially a table that was lifted from our 2019 sentencing practices report. So that's all I had on 5A, unless there are questions on that.
Any questions from the commission on the data? All right. So I thought it was important to see the data because, you know, part of this custody status discussion is, you know, if we keep it in some form, who's really getting it, you know, and if we decide not to keep it, why would we not keep it? I mean, the question, what the data sort of tells us is, it gives us information about who's actually receiving custody status to allow us to have a discussion about who do we think should be receiving custody status, if anyone. And so I think it provides a good backdrop for a more general discussion to kind of help us get to that point. At the last meeting, you know, Judge Larkin made the point that it's a philosophical discussion as to whether or not custody status should be in the guidelines. And I think that that's right. I do think it's a philosophical discussion, but it's good for us to ground it in the data so that we can sort of understand what is it we're trying to achieve with custody status, and are we achieving that goal? And if we feel like we are, great. If we feel like we're not, then you know, what could we do to hone in on what we really are trying to achieve here? So with that, I thought I'd put a couple of questions on the agenda as to try to get your minds thinking along those lines. And I thought we could spend a bit of time just discussing these points today. And then we need to sort of figure out next steps and where do we go from here. So the first question I had put on the agenda, really, I think the first two questions go together. It's kind of hard to answer one without the other. But I really wondered from the commission, you know, what concerns or risks does custody status address for you? And are those concerns the same across all cases, in all cases or all offense types? So I thought, you know, if you'd be willing, we could start there and hear what thoughts anyone might have on that front. What concerns or risks does custody status address, and are they the same in all cases? Commissioner Moore. Oh, and then Commissioner Knudsen after that.
Thank you, Madam Chair. Well, for me, the concern is recidivism, but recidivism means different things depending on the type of, you know, offense. I mean, no repeat criminal offense is obviously anything that is desirable, but I think we heard through the public comments, and what concerns me are repeat violent personal crimes, the types of things that have a direct impact on someone else's, you know, life, liberty, property. And those are the concerns that to me, I think custody status partially addresses. However, it may not be a complete, you know, it's certainly not a fail-safe for that, but at least it is one way of reflecting the risk of recidivism, and that risk becomes more serious, I think, with personal crimes and the crimes that are on the severe violent offense list.
Great. Commissioner Knudsen.
Thank you, Madam Chair. For me, the concern is just a blatant non-compliance with the probation or supervision terms. The most important one specifically is remain law-abiding. You know, we can adjust probation. We bring them in for violations when they relapse, when they follow some technical terms of the probationary sentence, but when they go out and commit the new crime while they're on supervision and on probation, that concerns me more, and in my mind deserves an enhanced sentence of some type.
If I could follow up, do you have the same level of concern regardless of the type of crime that they commit the next time around? Are there any places where you might feel like every crime is important, but some deserve more punishment than others if you commit them while you're still under custody status? I was just curious.
Well, if it's a felony level offense, I don't think it matters a whole lot. I think it's the custody status point should apply.
Okay. Commissioner Larkin. Did you hear me, Commissioner Larkin? I think you might be muted.
You can unmute her. She is muted. Shall I unmute?
Yeah,
her?
try
Unmute
unmuting.
me.
Okay, I just unmuted you, Judge Larkin. We can hear you.
Thank you. I don't know what happened while Commissioner Schnell was speaking at some point. My whole screen display changed on its own. And with that, my mute button went away, my video button went away. So I don't see that I have the ability to unmute myself anymore. I'm not sure why that is, but that's why you weren't hearing me. Regardless, my concerns are the concerns that I think the custody status point addresses are similar to those mentioned by Justice Moore and Judge Knutson, and that is recidivism, and not as a predictor of recidivism, but just sort of an appropriate consequence for somebody who recidivates while under some form of probation supervision.
And I'll ask you the same, is it the same regardless of what type of offense? And Commissioner Moore went to the second question, like, is it always the same? And I just want to make sure we hear from you. Is your concern always the same in every case, or are there types of crimes or not?
You know, I'm to some extent it is. I'm not willing to.
Okay.
I think there's a concern about sending the message that, well, even though you've been convicted of a felony, you're on probation, it's not really an important felony, so we don't really expect you to comply with probation by remaining law abiding. So I just don't know that that's the right message to send right now.
Commissioner Schnell?
So I hear, I think, for all of us, I think I've mentioned this before, there's always that pull toward a response to something. But I guess there's really, for me, it becomes a couple of different questions. And I think that your clarification, Judge Larkin, was helpful, and that you're not talking about recidivism from the standpoint of recognizing that custody status itself is not, there's no evidence that would reduce
Right.
recidivism, but that it is a response to the fact that they did reoffend. And the one question I have is the extent to which the system as it is today, does it have other or existing adequate tools to address that? And I think we've talked a little bit about this, but if I'm on probation for some felony, whatever it may be, and I reoffend whatever that may be, let's just say it's the same offense, the theft. And the question really becomes at some level, doesn't the system have a bite at the apple on my original underlying offense, be it a commitment or a probation execution of my sentence, or some other mechanism of addressing the violation from the first offense. And isn't that separate and distinct at some level from, from the new offense I committed? In other words, there are mechanisms, it seems to me, to be able to hold me to account for failing on the first offense and imposing a sentence on the basis of the new one. And I don't necessarily see the fact that how does custody status satisfy something that can't be satisfied through an existing structure that we have.
Commissioner Larkin?
Yeah, I think for me, it just goes back to what we heard so much during the public comments, that a person's more blameworthy. And I mean, that has historically been the justification for the custody point. Yes, absolutely. You can revoke the stayed sentence for which the person was on probation. You can impose and execute a new sentence. But the idea of the custody point is there's a little more bite to the new sentence because you were on custody status when you committed the new offense. So it's not that you can't, consequence each offense. I see the logic in saying your sentence on the new offense should be higher because you were on custody status, which is just sort of the fundamental historic purpose of the custody point.
Madam Chair?
Commissioner Strong?
Just to respond, because I guess I'm a little confused, because isn't that, and again, I'm not as a day-to-day user of this like the judges and probation staff or prosecutors, defense. But isn't that one of the objectives of criminal history? I mean, isn't that the reason we have criminal history? And that your point's about based on criminal history. But now we're saying that we have criminal history. We have the ability to consequence you, to use that term, for your underlying offense for which your custody offense. And we have we have that new offense, which obviously they're going to get the history point. So I'm trying to get a sense of just the extent to which the system has tools that are we not adequately using them, or that's the part that I guess I'm a bit confused by.
Commissioner Larkin, and then I think Commissioner Estrada also had her hand up. So
Sure.
in that order.
I think you're right. We do look at criminal history, but we've always included the fact of custody status. And to me, that's not unreasonable, because your criminal history includes, what offenses have you been convicted and sentenced for? And then another component of your criminal history is the fact that you have a history of committing new offenses, or while you're under probation supervision, while you should be on your best behavior. So I don't see that the custody status point is far removed from the criminal history calculation. In fact, it's always been a component of that calculation of the criminal history score.
Commissioner Estrada?
Personally, I don't think the custody status point addresses any of the concerns that have been brought up, besides adding on additional jail time. I concur with Commissioner Snell in that the history point is already being taken into account. The felony, the previous one, is already being taken into account in the history, so like the criminal history. So that is already a punishment for being on supervision. And in terms of blameworthy, I mean, again, I think this whole conversation is philosophical. I would make the argument if somebody is in the midst of addiction and they get sentenced for a drug offense, and 3 months later they get another drug offense, is that person more blameworthy than somebody who, let's say, successfully completed programming, finished treatment on March 10th, and then on March 11th, tomorrow, gets a new offense? One can make the argument that that person should know better because they've had all of the programming, they've had all of the services, they've had all of that stuff, right? So it can go both ways. I would actually make the argument that this person's in the midst of their addiction, and so you kind of expect that, you know, they're still in it, they haven't gotten the services, they haven't gotten the resources, and would probably be less blameworthy, in my opinion, than somebody who got all of the resources and then the next day after expiration doesn't get a custody status point. I would challenge people to kind of think about that as well. And then in terms of like you're on probation, you're just not following your conditions. Well, there's consequences for that, right? If you don't follow your conditions, there are violations that are being brought up, and it is a condition to remain law abiding. So there's going to be a sanction if you don't do that. Why are we then again adding another point? It just feels very duplicated in a lot of this, and it goes back to, you know, are we adding more jail time to people because we're mad at them, or are we adding more jail time to people because they're really a risk to public and victim safety?
I'm gonna make a comment, and then Commissioner Moore and Commissioner Larkin will go in that order, and then Commissioner Middlebrook. I just want to pick up on the addiction thing, because to me that's the second question here is, are the concerns or risks the same in all cases? And I think that's where it falls down for me. You know, I do think recidivism and recidivating when, as Commissioner Larkin mentioned, when you should be theoretically on your best behavior is the concern that custody status was designed to address. But it's not I don't think the concern is the same for me in all cases, because in some of those cases, I think we have people who maybe can't control their behavior because they, as Commissioner Estrada said, they are in the midst of an addiction, and it's really difficult. Like our job should be to try to get them out of that cycle instead of piling on. So I find places like that really problematic to just apply custody status in a routinized manner, the way that it's built into our criminal history score. You know, and when I look at the numbers today, it does feel like we are going to great lengths to punish addiction more harshly. Almost all of the DWIs were people who had custody status. Almost all of the fifth degree drug possession offenders were people who had custody status. So a lot of people in this pool are people who are struggling with addiction, and to me, that doesn't feel right. I think, you know, the sex offenders who had a previous sex offender, I kind of don't have a problem with those 2 extra points there. But all the folks who are struggling with addiction, that really worries me. So I do see some nuance here, and I don't think and I think to me the problem with the way our custody status is working today is it's a one size fits all type situation, and even the commission that went to the half point recognized that custody status was outweighing the prior offense in many cases. So they were trying to, you know, correct that concern as well. So they saw nuance too, and I think it's just not that simple. Sorry for going on too long.
Not at all.
Commissioner Moore, then Larkin, and then Middlebrook.
Thank you, Madam Chair. Two points. One in response to your statement that you just made, then one a general comment. In response to the DWIs, I thought it was noteworthy, the data on those, but it's important to remember those are felony DWI offenses. To get to a felony DWI, you have to complete, generally, if Judge Knudsen can remind me, I believe it's three priors in the past 10 years. And, you know, from a public safety standpoint, I always viewed those offenses as being, frankly, some of the most serious public safety offenses that I dealt with. You know, far more serious than a fifth degree controlled substance crime. You know, somebody that was, you know, buying some methamphetamine for personal use, you know, undesirable behavior, but in terms of danger to the public, the felony DWI offenses, I think, are very, very high.
Yeah.
Secondly, the issue of custody status. I was really struck by the presentation we had at the last meeting about the disparity in amounts counties are paying or supporting probation. I mean, I think this whole discussion sort of has a underpinning that everything is the same regarding custody status in the state of Minnesota. I can tell you from my experience in outstate Minnesota, that is far from the truth. The resources that might be available to Commissioner Estrada and people in the metro area, you've got probation agents in outstate Minnesota that are supervising people spread out over a vast geographic area, oftentimes with very little, support, access to treatment services, very much hit and miss. Transportation is an issue. I mean, and so I really think there's something behind the presentation that was being given last time about the need for us to take a really good hard look at what we're doing with regard to supporting local probation. Because, frankly, custody status doesn't mean the same thing in Waukegan or Nobles County than it might in Washington or Dakota. It's just a different thing. And so, looking at custody status kind of across the board, I think doesn't get to that nuance. And that's part of the problem that I'm having. Success on probation can be, oftentimes is an offender-driven problem, but it can be exacerbated by disparities in access to services.
Thank you. Commissioner Larkin, then Middlebrook.
Sure. Two things, I think. On the DWI, I had sort of the same reaction. I mean, we've had people, members of the public, come and comment at the end of our hearings asking us why the presumptive sentences for felony DWI are so low to begin with. And I think that's happened twice. We've been asked to look at those by members of the public and consider whether they should be raised. So, and yet we're now saying, well, DWI, that's addiction. Maybe we should take away the custody point, which would reduce the sentences. I think after the significant public input that we received in December, we need to step back and ask ourselves if we're going to do anything with the custody status point that reduces sentences, how do we justify that to the public? Because that's how the public views this. You're reducing sentences. So I think, it's great from an academic perspective to talk about data and what are we trying to accomplish and all of these things. But at the end of the day, the public is watching this asking, why are you reducing sentences? And we need to be able to answer that question in a way that they understand if the public is going to accept any changes we propose. So I would just ask that we keep that in mind in these discussions.
Commissioner Middlebrook and then Commissioner Estrada.
Thank you, Madam Chair. I would say that I agree with many of the things that have been said here. One of the things with the custody status point that I find the most concerning is that it is, and you've heard this numerous times about how it's double or triple punishment. And I think there's these other tools that do increase the sentences. History, for one, the violation of the probation condition. There's all kinds of sanctions, including imposing and executing the sentence that can happen. And a lot of the offenses, especially, you look at the DWI and even on the severity level 4, a lot of the offenses that are included in there are enhanced from misdemeanor, gross misdemeanor, and then felony level. And so those that, a lot of them may be on custody status for the offense that's actually enhancing it to the felony level and getting it to that status as well. One of the things I think that concerns me the most with the custody status is where it puts somebody who would be in a state probationary sentence and sends them to prison because of that custody status. And I think that for me is one of the biggest concerns, because I don't know that when they're on the line like that the custody status should necessarily push them over into the prison sentence. I think that there's a lot of other things that maybe can be looked at, particularly again on those lower level offenses where the line is stayed sentences and then the commit sentences. I totally understand that people believe that they're more blameworthy if they're not being accountable while they're on probation. But what I see in so many of the clients that come through the public defender system is we have so much addiction. We have so many that are mentally ill. We have so many that are really so poor, and a lot of the crimes are poverty driven. They're committing these crimes to survive. And those are the concerning ones for me, that this custody status is pushing them into going to prison rather than being able to try to work things into the probationary setting. I would agree with Justice Moore completely about the resources. And that's another thing, is that there's such disparity across the state for people who are on probation. And what we saw too before the 5-year cap on probation terms came in is some of these people were on probation for such a long time period, and there may be a really huge gap between their offense and the new offense, the prior offense and the new offense. And it may be just because of that really long probationary term. I don't know, but those are the concerns that I see with the custody status point.
Commissioner Estrada.
This is more just an observation than any type of influence going anyway. I also, the felony DWI was surprising to me to see how many numbers were there, but then I also keep looking at our mitigated dispositional departure rates. And I look at the 58% felony DWI departure rates, and I look at the 60% failure to register departure rates. And so it's sometimes hard for me to kind of hear like, oh, we're so, concerned about these severe offenses and things that sort, and accountability when there is this high departure rate. And again, that's just an observation and looking at it, is there any correlation with that? Justice Moore, I really appreciate you highlighting the left resources around the county. One thing about that presentation, I did, as I mentioned at the last one, I did participate in that focus group through Hennepin County, and then met with our area directors. And one of the things that we did learn was that Hennepin County, who does have a lot more resources than a lot of other agencies, the things that we are implementing is working. The evidence-based practices, the COG one-on-one, the cognitive skills all the way across the board, trauma-informed care, things of that sort. So I do believe that we need to free up some funds so that we can get the rest of our probation departments those same resources.
Sure.
Commissioner Chanel.
So I want to, I'm set, you have to be, I'm super sensitive to the issue of, to Judge Larkin's question about how do you justify this to the public. I feel that, I honestly feel that pull. I mean, I spent a lot of my career focused on investigating cases with the goal of having people held accountable to the fullest extent possible. And I believe that's important, that accountability does become important. But I also feel this sense of pull around the extent to which it works. And this is the part where we have the position, and I think in many cases of looking at these issues, and I hear what you're saying. This is not just an exercise in kind of academia, and that there are real people behind these situations. And yet, I think when we look at the data of saying, well, what does work, I do think that this is where we have to give some attention. And one of the things that's not here, and I should have asked for it. I did ask for it like early on, but there was, remember that the pull up some data that you guys looked at was, what was the added length of time that that was actually added when we started to look at, custody status and where they fell in general? What did it mean from a time standpoint? And I think, when you start to look at the actual difference in time, somebody, we're getting in some cases a month or less, or 3 months, depending upon the offense and that kind of stuff. It was stunning to me because, granted, we're talking about a month or we're talking about 3 months, and the question does become at some level, is that the difference between justice and no justice? Is that the difference between prompting the behavioral change that everyone in this room wants to see happen? We all want to see happen. We don't want these people to end up going back out. And will some of them disappoint us? Absolutely, they will. And for a host of reasons that has been discussed already. And so what I think is really important, that as we look at this, we engage with people around this whole question of what does blameworthiness mean? Does blameworthiness mean that because I have this new offense that additional 30 days or less of time, or 3 months, or whatever it may be, does that truly account for the blameworthiness that I'm hearing belongs to these folks? And is at number one. Number two, does it make a difference? Does it work to reduce the risk of somebody offending? And we can argue that it does have the effect of incapacitation at some level for that month, 3 months, 4 months, 6 months, whatever it may be. And then finally, I guess the question is, it's one thing for us when we talk about things like shortening sentences, when we make statements like we're just shortening sentences, which the effect I understand is a third, maybe it's a month, it's 3 months, 6 months, whatever it may be. And I guess the question really then becomes, this is super heady, complicated stuff. And I will tell you, I'm as much a student of it, learning about it as over the last 3 years that I've had the chance to be involved here. But I worry sometimes that when we talk about things like the public expects and that kind of stuff, but they, do they know? Because I oftentimes don't think we necessarily know what that really means and to what extent that achieves the kinds of objectives that we talk about here. I understand 100% that we feel like and have a sense of outrage by the fact that these people have not lived up to what our courts have imposed on them, their agents, all of that kind of stuff. But I think the challenges that we have with one size fits all, and I think one of the things that I think Minnesota has a long history of, and we can argue about whether we should have this or not, but a long history of really trying to right size the intervention, and certainly sometimes we hit the mark, and certainly there are times we don't. But I worry sometimes that when we talk about custody status point, that the difference between quote unquote justice and a lack thereof rests on custody status point. And again, I'm not saying that that's what you're saying, Judge Larger. I'm just saying that in general, there can be a sense, or people take on a perspective that what we owe, and that this explanation is really the difference between the people who support a different look at custody status. In particular, for me, when I look at the range of tools that exist in existing sentencing guidelines, and with the people that to me, I think represent some of the greatest risk, I just worry that we have these conversations and we can mobilize a lot of people, but that missing in the conversation is further conversation. And that's really what was the intent of the motion I made when I withdrew, was to say, look, if the question is one of just, should we shorten sentences in Minnesota? We can get we're going to get an answer that we got. I think the question of what it is that we want to achieve, I would hope that we would and could engage members of the public and other stakeholders in that kind of a conversation that frankly is, the opportunities like we're having right now is something that stakeholders simply don't get. And to me, one of the things that I think when I made the motion was to try to get to a point where perhaps we could have an opportunity for broader engagement with stakeholders and community, and that the Guidelines Commission, could not just look at these issues from this standpoint, but actually do a roundtable or whatever it may be to try to engage in the deeper the conversations about the full range of issues that have come up on both sides of this, and talk through it without with a level or a degree of specificity that's beyond justification of reducing sentences, because I think that there's more complexity to it, especially given the range of tools that it currently exist, and or that we could tweak along the way to achieve what we need to achieve. So thank you for that. Sure.
Commissioner Larkin and then Commissioner Moore.
Commissioner Estrada, you mentioned that the things you're doing in Hennepin County are working, and it would be your hope that, funding resources could be allocated such that other counties would have the resources they need to put in place these successful processes. And I wonder if there's any data you can share with us that shows, explains, okay, here's what we've done, here's how it's different, here are our probation outcomes as a result of those procedures, and our outcomes are better, and that people are not reoffending and they're not being sent to prison. Because all along, I feel like that's something concrete that we could have that would, answer the questions like, well, we would rather do this. This is a better use of funds. And here's some proof that it works. And here's some proof that it's worked in Hennepin County. And that, perhaps justifies some changed custody status point usage in terms of calculating terms of imprisonment. So I wonder, Commissioner Estrada, is that data that's been collected that you can share with the commission?
Commissioner Estrada, you can answer that.
So if you remember the presentation, what was it, the gentleman's name who presented to us?
Carl from CSG?
Yep, Carl gave us that presentation. I believe that there's a slide in there that shows kind of the recidivism for, I think, like the first 3 years or things of that sort. And if you look at it, it'll break it up by DOC and probation. I believe that first big circle is Hennepin County. If you go back to it, and I don't have it up, I'm happy to kind of offline go through the presentation with you. But that first circle will show where we fall on that recidivism table across the state. Otherwise, if you're looking for, some of the things that we're implementing in Hennepin County in regards to evidence-based practices, I can ask our directors if they'd be willing to come and talk to the commission about what we've implemented in Hennepin thus far.
Who is Carl? You mentioned a presentation by Carl. Could you remind me who that was and when we had it?
That was Carl Reynolds from the Council of State Governments. He presented on the Justice Reinvestment Project that's going in Minnesota last month.
Last month. He presented last month.
And so he presented a slide showing what Hennepin County's outcomes are recently in terms of recidivism.
it shows across the state recidivism for probation departments and
Okay,
DOC. It doesn't specifically note which counties are which, probably intentional. But we, as I mentioned, had a conversation in Hennepin County as to where we fall.
okay,
So
but
we could get some clarity.
yeah,
on
that's
that.
a secret then. That's the information we need. I mean, if the pitch is there are programs that work and they've been demonstrated to work, and here are the numbers from a particular county that show they work such that it justifies a reduction of presumptive prison terms, then we need those numbers.
Okay, so we can, so that's something we can, that's something, I was gonna ask in a minute, what other information people wanna hear? I think that's one of them. So we'll add that to the list. But
Okay, can
Commissioner
I
Moore
just-
has-
And I'm
But-
sorry, just to follow up so I understand. So what we had from the last meeting is just something that shows that local county probation departments have more success than DOC counties or DOC supervision.
I don't think it was that clean.
It's
Yeah.
not that clean. It's
Yeah.
just across the board where people are falling across the board. It's not that
Okay.
specific.
Okay. But like I said, I'm asking for it. I think if we have information that says, okay, here's a county, here's what they're doing, it's working, they're successful, look at their numbers, that would be good information to have.
Yep, I agree with that. Okay, Commissioner Moore.
Thank you, Madam Chair. I think one of the problems that we fell into was kind of the all or nothing position that we ended up being in, which I think is really unfortunate because I agree with Commissioner Schnell. This is a nuanced issue. And Commissioner Mitchell too. It is a nuanced issue. It is not, every offender is unique. There's different needs in different parts of the state. And one of the, I guess, segueing to one of your questions about what other information we could use, the rate to which district court judges are waiving custody status points at lower level offenses, if we have access to that data, I think could be helpful, because I like the idea of giving to local district courts the ability to make good decisions for their communities that are consistent with public safety. And if waiving custody status is part of that, then, for the lower level offenses, I'd like to know if that's been utilized and frankly, if people think that's working. I guess on a broader scale, looking at custody status, I think, and my recommendation to you, Madam Chair, will be that you reconstitute the small working group that had been looking at this. Because I also agree with what Commissioner Schnell was saying. I think these issues are nuanced and challenging, and having the debate before the full commission on a meeting by meeting basis, I don't know if that's advancing the ball sufficiently. I mean, we're getting some broad, good discussion out there, but in terms of getting to, some nitty gritty policy recommendations, I just think getting that small group back together, the same people that were working on this earlier, so we don't have a variation in membership, and giving them, some time to look at this, perhaps not in the glare of the guidelines committee meetings, but to come together and talk about some of these things and perhaps come up with some ideas that we haven't yet heard of or thought of.
All right, thank you. I wanted to make a couple of comments too. I have too many thoughts swirling in my head. So it's hard to know where to begin. One thing that really struck me about the public hearing was I feel like that the folks who were concerned about the elimination of custody status really pointed to violent crime and a concern that the public concern was about violent crime. And so I was actually relieved to see the numbers that we got today, because a lot of the people who are actually receiving custody status are actually people that are on our, who've committed a much lower level felony. There are definitely people on our grids who have committed violent crimes who also get custody status, but it's a much smaller group than people who have pretty low level offenses. And fifth degree controlled substance was by far the highest offense on the grid there. So I do see differences there, you know, in what we could be achieving. I mean, you can meet the public concern by addressing violent crime, but you don't have to pull everybody into the same net to necessarily do that. Again, I see a lot of nuance here with the folks, and what we've learned since the guidelines were created 40 years ago, 40 years, which is incredible, is how to work with offenders. And the science of behavioral change has moved tremendously. And, you know, so one thing that Minnesota has always done is we've committed to keeping people in the community because we think that's better for behavioral change. And it actually is. It actually is better for behavioral change. So, so then I think about, you know, the folks who are coming before coming to us with these felony convictions. What is the best response to the offense that they have committed? And that really differs based on where that person's at and what drove their criminal behavior. And so I think for me, you know, what's sort of the mismatch is the custody status is a one-size-fits-all answer to that question. And as Commissioner Schnell said, it's not necessarily something that's going to result in behavioral change to increase the sentence in every single case. But I can see cases where it makes sense to impose it. So, you know, I'm not saying that it's an all or nothing thing for me either. I do think there are places we could be having a discussion here. I'm actually very intrigued by what Commissioner Schnell said about, you know, that part of the reason that he wanted to delay the vote was so that we could engage in more dialogue. And I actually think we should start talking about that. Like, what could we do to increase the dialogue and have more interaction with stakeholders on this issue? I can think of 2 times in the recent past when the commission has done more outreach, one being one being on the drug offense issue. The commission actually held a roundtable and invited people to come to the commission and have a dialogue during the day about some information. And then the second was when the commission was actually looking at the whole criminal history score and had a lot of ideas on the table for ways that it could be changed. And that was more of an invite to testify, but it was a broader in reach, you know, to get some feedback. So I would like us to be thinking about, I think we should do something like that on this issue. I would love to engage in a broader dialogue with our stakeholders about some of these issues that we've brought up, because I think every comment today underscores that there are, you know, 10 sides to this issue, that there's a lot to think about to try to get to some place that we might all agree is the right solution. So I would like us to start thinking about that. So in that vein, you know, I think we don't have unlimited time today, so we probably should start to wrap up this discussion. But I would like to hear if there's anything else that commission members, is there any other information that you would like to see that would help with this conversation? And if anyone has any reactions to sort of join some sort of a broader stakeholder engagement, I'd also love to hear about that.
I'm sure if I could just on a data side,
Schnell.
I'm just wondering if like that piece, you guys already did it, I asked about it. Remember that where you did some averages, lengths of additional time that custody status created?
So how did it change the sentence?
How did it change the sentence when we really looked at it across the board numerically and that kind of stuff? Yeah. And what the change actually was by months. I just think that would be really, you know, it was really when I saw some of the preliminary, it was, there was some really just preliminary data, like they pulled 25% of the cases or whatever and multiplied it out. But it was pretty stunning to me just how, in many cases, how little it was. But that's something I think to look at.
I think that's good information for us to know. Oh, I'm sorry, Commissioner Knudsen. Again, I'm still having trouble figuring out where to look. Please go ahead.
Thank you, Madam Chair. Just following up the last comment from Commissioner Schnell, it kind of begs the question of why we're spending so much time on this whole proposal of eliminating the custody status point. And in my mind, it's diverting us from dealing with these other issues where there are anomalies. I think we've got bigger fish to fry. Where and how can we identify the harsh, unproductive, out of line sentence practices that are embedded in the guidelines? So I just want to talk a little bit about how I view this again, kind of going back to where we started from. As Commissioner Schnell said, one size doesn't fit all. So we need to recognize the factors that distinguish an offender's actions from another offender. And so we go back to the situation where a felony offense is committed, they're placed on probation or whatever, another offender does the same thing. Now they both have 1 point. One commits the next offense within the year while they're on probation. The other person commits the next offense 3-4 years from now, so they have the same criminal history points, but one's on probation and one is not. One's on supervision and has expectations due to that sentence. The other is not. I think those two individuals should be treated differently and not just receive the criminal history scores and we sentence them exactly the same. One size doesn't fit all. Offenders know this most of the time. They respond to that. It's human behavior. And so we keep going back to these so-called harsh punishments or where it trips and causes a drug offender who relapses to go to prison. Well, I just don't see that because judges have a lot of these tools to waive the custody status point, to exercise their discretion in departing. And so even when that second offense is committed, there isn't the double or triple punishment. The person is sentenced on the second offense, and then they agree to the execution on the first offense, which doesn't add any additional time or punishment, and it's all wrapped up into one sentence, basically. So the whole discussion on custody status point, I think, has gotten us down a track where it has not been helpful in the broader issues that Commissioner Schnell is talking about addressing. Thanks.
All right, Commissioner Larkin and then Commissioner Schnell. Sorry.
Yeah, I think I want to echo what Commissioner Knudsen said, because, we oftentimes talk about this being double or triple punishment. But, one thing we have to acknowledge is, first, as Commissioner Schnell indicated, with the exception of you're on for a crim sex, you commit a new crim sex, you get 2 points, in which case the step increase could be pretty significant. When you're just going up one box, it's not a huge increase. I mean, it might be, it's always at least a month because that's how the boxes are written, but it could be 3 months, 4 months, 6 months. But the reality is, very infrequently does the person get consecutive sentencing on the second offense. So it's more like 2 for 1, not double punishment. I mean, it is sort of that the custody status increase that's placed upon the second offense is what gives some semblance of punishing for both things. Because if it's concurrent sentencing and there's similar offenses and there's no custody point increase, the offender is basically getting a 2-for-1. I mean, we don't want to say that out loud, but that's what's happening. I mean, you committed one felony, you've committed another felony, you get consecutive sentencing on the other felony, and if it's a similar level offense with no increase as a result of custody points, you're basically getting one sentence for 2 offenses. So it does seem that the custody point serves some purpose there. So maybe that's something else we should be talking about in all this. Maybe we don't have custody status point, but maybe it is more about a greater use of consecutive sentencing to make sure people are getting punished appropriately for their 2 offenses. So just wanted to chime in on that.
All right, thank you, Commissioner Chanel.
So I would just say that I do think it's a worthy conversation. I would just say that, and I appreciate the clarification, Judge Larkin, because I would agree that there are options of the ways that this gets looked at, and perhaps that is something that should be considered. And I would also say that in many instances, we talked about this before as well, there are other tools that exist as well that have not been used, or that that we don't always look at. And so again, going back to the whole notion of custody status and what we're trying to accomplish is especially when it speaks to this whole notion of true public safety, and holding people to account, so forth. I mean, are those tools being used in the ways, the tools that exist, some of those aggravating factor things that we've looked at earlier, are those being used in the ways that they could be? And as much I also think that the one concern is that when it just becomes squishy about from a pure discretion standpoint, I think there we start to see disparities. So how do we find the right sweet spot? And I guess that's really the point of the conversation. And I do truly believe that there is value in this. And I think, this goes back to some of the, I would argue the original charter, and that is what is a rational system and how does it make sense? And I'm not trying to be overly philosophical, but I do think that a system that is simple and just makes some rational sense and then really serves that the broader justice and public objective of what is it that we're trying to do. Because I would agree with you, Judge Larkin, that if it's a 2-for deal, that may not be that's not in the best interest of complete transparent accountability or sentencing either. And I think you're right. And so how do we distinguish those situations in a way that makes some sense?
All right, just going back to my question of what else we want to know, there's a couple things I want to know, so I just want to throw them out there. Number one, since we saw such a high rate of DWIs with custody status, I'm curious if any of that is from the underlying offense that would have elevated their current offense to a felony. So if they're on for their last gross misdemeanor before it becomes a felony and then they commit the new one, is that why they're there? I don't know if you want to see that for other enhanceable offenses as well. If to the extent, if it's possible. I don't even know if some of the stuff I'm going to say is possible. I'm also personally interested in, of those that are in the stayed portion of the grid, what proportion receive stays of imposition versus stays of execution, because that affects whether custody status actually changes that sentence. And I'm interested in revocation rates for people with custody status points. So those are some of the things. And I think recidivism, even, I know that we've done recidivism in the past, sort of looking within our own felony database. So I don't know, that might be something we could look at. There's just, I just had those are just a couple things that I thought I'd be interested in seeing. I understand the staff is overloaded right now with fiscal notes, so I don't know how soon we could see anything, but those would be the list I'd start to create. And then I can see Commissioner Ladd and then Commissioner Larkin. So Commissioner Ladd.
Thank you, Commissioner Mitchell. And I would just note that my silence so far hasn't been because I haven't had anything to say. Everybody was sort of articulating my thoughts. And so I just say ditto, first of all. I just had a couple of follow-up questions to the points that you just made, Commissioner Mitchell. When you talked about first the revocation rates, you mean the revocation of probation where they're then sentenced to prison? Is that what you were meaning?
Right.
I would be interested in that as well, and I would also be.
Yeah.
And again, I guess I'll say this, and I don't know if this data is available, but just from a practitioner's experience, when we're doing this, typically someone gets revoked and goes to prison. It's usually not on a first violation. It's like 4 or 5 revocations, hearings down the road that we get there. And so I don't know if there's a way for us to know that if people are getting a sentence executed as a result of a revocation process, if it's, is it because it's a first revocation or a last revocation? The reason why that matters is because it kind of goes to a point that Commissioner Estrada brought up about dealing with persons with addictions and mental health and treatment sort of things. I would just say, again, from a practitioner's perspective, there's a lot of departures that are weighted on the fact that someone is going to treatment or they're amenable to community-based services and treatment. And that is the reason why the departure is being granted by the court, and not always in agreement with the prosecutor, but the court does that. And I sort of feel like that's probably the situation with the mitigation on the felony DWI offenses as well, that those departures are based heavily on treatment reasons. And so I don't know if there's a way for us to know that in terms of like when sentences are getting revoked, if we know if it's how many times they've previously had a violation before their sentence is finally executed or not. Because from my perspective, they're doing their prison sentence on the installment plan, and when they end up going to prison, there's not a lot of time left on the sentence. And so that's where some of this comes into play in terms of new offenses being committed while they're on this supervision, when they've had these multiple violations and they're getting a 2-for-1 or in some cases 3-for-1s because they've continued to get these new offenses and they're getting concurrent time on it. And so it doesn't feel like there is a consequence for either doing what they're supposed to be doing or even a consequence for the underlying offense. So that's one thing I'd like to just see if that's an option. The other question I had was, you indicated something about the stayed sentences, stay of execution versus stay of imposition, and them not being sentences. I didn't understand what that point was.
That's because for a stay of imposition, there's no sentence pronounced. So even if you get the custody status, that number it's not going to go up, right? Whereas a stay of execution, the court has to pronounce the actual prison sentence at the same time.
But if the stay of, but just so that I'm understanding that, if the stay of imposition is ever revoked and it is a stay of execution, whatever the sentence would be, which would include the custody status point, it would trigger that additional time. Correct?
Yeah, it would.
Okay.
Yeah.
Okay.
Or if they're successful, it'll become a misdemeanor conviction.
I just wanted to clarify that. Thank you.
All right. Okay. I think we are probably. Did I get everybody who had comments? Okay. I think we have used up all of our time on this one, and we have other things on the agenda. So I want to make sure that we move on to those other things. Demographic impact statement policy. That's number 6.
Thank you, Madam Chair. Thank you for that interesting discussion, Madam Chair and Commissioners. I found that very interesting to hear. In 2008, the Minnesota Sentencing Guidelines Commission staff started doing demographic or racial impact statements for certain crime bills. And so when it was never really anything that the commission formally adopted or ratified. And when I took the position in 2014, I thought it was appropriate, first of all, to make a policy, and second of all, to involve the commission in some sort of oversight over it. The reason for making a policy is, I think, bias being what it is, it seems like it's a particularly appropriate area to come up with a formalized policy rather than just saying, oh, I wonder if this is something we should be investigating. Just investigating it, basically all cases where it applied. And I thought it was something appropriate for commission's oversight. So I presented, and some of this history really is contained in the existing demographic impact statement policy. So I presented sort of the process that I thought was appropriate to the commission. The commission ratified it, and eventually the commission decided to get involved in authoring the policy itself. So the current policy is authored by the commission. It's published by the commission, and the particular point of contention that was brought up by State Representative Pinto has to do with the bottom of the first page, where it talks about the MSGC prepares and forwards demographic impact statements to the appropriate committee chair. And the action that was voted on at the last hearing was to broaden that, to include other leaders in the respective House and Senate crime committees, as well as the author of the bill. So that's a change. We could republish this policy just with that change, or if there are other issues about how the policy is prepared, we'd be happy to do that. But what I would call to your attention, well, two things. One is because this is not legislatively mandated. This is sort of in my perspective, something we do when we have resources to do it. Unfortunately, the way the legislative session works, that's probably the time of the year where our resources are stretched the thinnest. So we ended up not doing demographic impact statements for all bills that would have been appropriate for demographic impact statements last year. And this year looks to be very similar. We haven't done a single one yet. We just haven't had time. We are, as you pointed out, Madam Chair, we are really stretched thin right now, just covering the work for the commission as well as the work for the legislature. The legislature's been very active, as I'll be discussing in my executive director's report, and we've been very busy with fiscal notes. Honestly, don't know the number of if you look on page 2 where it says when prepared, this talks about the significance threshold that our current policy has, which is if the bill, according to our estimate, so we do the fiscal note, we estimate basically prison beds, and then we send it over to Commissioner Schnell's folks, and they put a price tag on those prison beds, and that's the fiscal impact. So in the course of that, we come up with how many people who are not now felons will become felons as a result of this bill, or how many people who are now felons will cease to become felons as a result of that bill. If that number is plus or minus 50 per year, then it meets our significance threshold. The other avenue for significance is if the number of prison beds that are needed is plus or minus 10 beds, then it also meets our significant threshold. And we've had a number of bills that, as I previously reported to you, that do meet those significant thresholds, either one or both of those significant thresholds, particularly the prison bed numbers. We've had some pretty big prison bed numbers. I'm not suggesting that we'll be able to do fiscal or demographic impact statements for all of those, because we don't always know who those occupants of the prison beds are, but we certainly do in some cases. And we just haven't had the resources to do that. So this is something we could bring before the commission at a future meeting to just modify that one statement at the bottom of the first page, or we could do other modifications if the commission's interested in looking at that. We don't have any language prepared for you at this meeting, but if that is something the commission wants to do, to essentially take last month's action and put it on this statement, or this policy, we can do that at the next meeting.
So just to clarify for everyone, the action that we took last month was to direct Nate, our director, that if they do prepare a demographic impact statement, that they would provide it not only to the appropriate committee chairs, but also to the ranking minority members and the authors of the bill, because it was an author of a bill who raised the issue. So I think we should just make that a permanent change to the policy. To me, that seems like it will inform the folks who really need to know. I think it's important for both parties to always have the information. So by providing it to the chair as well as the ranking minority member, we ensure that that happens. And then the author obviously has an interest in the bill. And so I think it makes sense to me that we could provide it to the author as well, especially if they don't happen to be a chair or ranking minority member. So that's where I would like to go with it. And I don't know, does anyone, what does the commission think on that? Any comments?
Madam Chair, are you suggesting taking action at this meeting or bringing it?
No, I think we should draft it and bring it back.
And if I may, just a couple of drafting comments that I'd like some guidance on. One is maybe changing author to chief author. The reason for that,
Yeah.
there can be bills that, particularly popular bills where everybody just wants to be an author, and so you can have a lot of authors on some of these bills. Sometimes they make clone bills because they fill up the number of authors that are allotted for a bill. So they just have like multiple bills so that they can.
It only happens in the House.
I know.
Yes, Senator. Yes, Senator. So the other suggestion that I might make is to include the vice chairs as well. I mean, I kind of think of the leadership for each committee as being a triad of the chair, the vice chair, and the ranking member. But I guess that could go either way.
Yeah, I don't have any objections to that. I think Commissioner Knudsen was the one who reminded us of the need to inform the ranking minority member. I think that was a good call. I didn't even think about the vice chair. I forgot there were vice chairs. So I don't have any objections.
All right. Well, Madam Chair, I'll be happy to draft that.
Commissioner Middlebrook has a comment?
Thank you, Madam Chair. I just have a question, a little somewhat related. Have you done any of the demographic impact statements this session?
We have not. So there's somebody who, actually I don't know the person's biography or role. He may or may not be a lobbyist, but there's somebody who was interested in, there was a significant bill last year to, it was termed as legalize marijuana. I think of it more as regulate marijuana. That certainly had some impact, and they were asking, where's the demographic impact statement? And we were like, we just didn't have time last year to do a demographic impact statement. There's another bill this year that, well, I think it's actually a reinstatement of a bill from last year that would do some of the same things, but on a much lower scale. It would create mid-levels of marijuana possession, for example, that are not felonies and not petty misdemeanors. Right now, there's nothing in between those. And that person was also interested in the demographic impact statement of demographic impact of that. So, I mean, I think that's very reasonable, and that's something we probably could do, but we just have not had time to do it. So, yeah, and the other one, which honestly would just be too easy, would be the bill to make 60911 mandatories hard mandatories. I mean, we should be able to do that, no question about it, but we just haven't had time.
All right, Commissioner Estrada.
Can I just say something about like the time of that? I know that after the murder of George Floyd, this commission was intentional about looking at disparities in everything that we do. And I recognize you guys are short staffed and here we are asking for a list of 1,000 other things to do. But I think that this topic and demographic input in bills that may become law is important, and we can have the capacity to do that, and maybe break up some of these other tasks. Possibly we can do that, but I think that we made a commitment back then that we would really be looking at disparities across the board.
Yeah, that's a good point. Commissioner Knudsen?
Yeah, I echo that comment. We've got those thresholds, so if it meets a threshold, we should figure out how to suspend some of our other activities during the session and be able to deliver on that. But the other, I think we should have that limited distribution. I don't know if we need to include the vice chairs, but I guess I would support us also publishing it on our website so that anybody from the public could go to our website and have access to that demographic impact statement.
We do publish them. I just don't know how real time that is.
Yeah.
Maybe you can answer that.
That's a good question, Madam Chair. That is correct. We do publish them. I kind of think we do it at the end of the session, like sort of after it's too late, really. So, and it's a little bit hidden, to be quite frank. So we could do that in a more prominent and real time way. And if you want us to prioritize demographic impact statements over commission work, we might have a light meeting. But honestly, I didn't think there was anything light about your discussion today. I thought it was a very interesting discussion. So, and that didn't require any staff input. It was basically a chair-led discussion. So if you want us to do that, we can do that. The first committee deadline is the 25th of this month. So in theory, we shouldn't get any fiscal notes requests, starting, I don't know, in a couple of weeks. We should in theory stop getting fiscal note requests. But then again, there's always amendments
and that might be a good time to refocus then on demographics, right? Because the bills will still need to be heard in the second house. There's still the potential for conference committee discussions on many of these bills. So, it would allow you to sort of narrow in on the bills that are live and actually making it across to the other side.
And that's one reason we didn't do the marijuana bill,
Yeah.
just because last year's marijuana bill, because in my opinion, it didn't have any, I didn't see any movement in the Senate, and I didn't really think it had a chance to. So.
Yeah. Commissioner Schnell.
I just would think that along the way here, it's already March, and it probably won't be long before we'll be starting conversations, at least thinking about the next biennial budget request. And maybe along the way as we're doing this, and I think to recognize the priority of this, is this something that staff along the way as you do some of this work could think about what would it take to accomplish this, and then so we could quantify that and at least bring that forward as we think about we're a ways off, we're in the middle of this one yet, but I think the next biennial budget would be a reasonable request, and I think it sounds like it's a priority for members, and I think certainly is of significant public interest.
Yeah, I would agree with that. I actually do think, I've talked to Nate behind the scenes. I do think it's time to be asking for more staffing. I think that our staff work incredibly hard 12 months out of the year. There's never a time when their work does, where they have an ebb in their work, because there's always something else going on. When the legislature's down, then it's time for the new guidelines to be created. There's always something going, and I feel like they've been behind the 8 ball staffing wise for a while, and that we really should be taking the opportunity to increase that staffing level.
Madam Chair, I would agree with that. I've been thinking for a while about the possibility of adding And my reading of our charter statute is that I would have to get approval from you to add a position. Maybe I'm reading that too narrowly, but I think that's what it says. I've been thinking about the possibility of adding a research supervisor, a role we don't have. Because I mean, I think it's evident that, basically the wheels kind of came off last year when we lost a staff member. Mm-hmm. Well, losing a staff member is not, an unforeseeable event. You shouldn't just come to a grinding halt because of that. We're still trying to catch up. So it's, I think to add that would really give the commission some additional capability. So I'm definitely considering coming to you. When would that be? Probably this fall, to talk about the next biennial budget request, because that would be a change of it.
All right. All right, any other comments on this? I think the direction is that we want to see some potential language change to the policy. Anything else there? Okay.
That's what we're looking for. Thank you.
All right.
So vice chair, maybe not so much on the vice chair. Is that what I'm getting from?
I don't have strong feelings with the others.
I guess I'm kind of asking the former legislator.
Yeah, actually, Judge Knudsen, as a legislator, you probably would have the best view there.
I think he's.
Oh, he might be on a phone call.
Yeah.
Okay, that's fine. But we can ask him offline. All right, let's move on to the. I just have a real short, teeny update on the Governor's Council on Justice Reinvestment. That's the presentation we had from CSG last month. I had hoped to be able to. So anyway, the Council on Justice Reinvestment wrapped up its work in February, and so what Carl had presented to us was sort of the full body of work that the working group that had been working much longer than the council had been working on over the past year, or not quite a year. And our job as a council was to prioritize the recommendations from that report of the working group, and then make those recommendations to the governor. I'd hoped that would be in a publishable form by this meeting, but it's not yet. So as soon as it is, we will provide it to you. But I will just sort of informally let you know that the things that it rose to the top for the council were encouraging the legislature to provide adequate funding for community supervision. There is already a bill in play in the system, so I'm really hopeful that at least some additional funding will be provided to community supervision this year, and that we will start down the road of sort of fixing the funding formula longer term so that we always have adequate funding. And then we also, had a lot of support for establishing an implementation committee to continue work on the policy side of community supervision. Some of that work could be done without legislative change. Some of that work needs legislative change. So I'm not really sure where we're going to land on that, but the council at least thought that was important. And the council was also very concerned about adequate funding for mental health services because, many of the folks who come through our system also need those services. And so it's really part of a larger conversation that's happening at the legislature as well as to what services should be provided in what form, where, and how do people access them. Some of you may or may not know that there have been changes to Rule 25, which was sort of the entryway to those services in the past. And what do we need to do to make sure that entryway is still working? So that's my informal report. We will hopefully have something more formal to share with you down the road. I don't know if Commissioner Shelf, there's anything else you wanted to add, or is that sort of?
I think the bill language will get, was kind of, I think last night I saw just some of at least the stuff before it goes to the reviser, but I think it should be done in the next few days, we're hoping, and next week we'll be out, and it really addresses, all of the things the chair talked about. But I also think it really addresses a lot of the EBP, the evidence-based practice side of this, which is really an important consideration because that is where the data points to achieving better outcomes. And so that, to address the Justice Moore's kind of notion around the trying to avoid the justice by geography because of a lack of resources in a given community. So I think there will be some things that will be very beneficial, and frankly, because it's a nonpartisan action, and I think there's a strong likelihood that we're going to see this get across the finish line. That's what we're hoping.
Yeah. All right. Any questions on that? Okay. All right, so let's move on to the executive director's report. Nate.
Thank you, Madam Chair. So I had 3 sub-items under the Executive Director's report. The first is the update on the electronic worksheet system. Thanks to Commissioner Schnell's outstanding IT staff. They're very accommodating on this, and they are probably, they may be on track to, I don't want to overpromise, but maybe by the end of the month, we may actually see implementation of that. So the interim policy that was adopted in January could take effect on sentencing worksheets as early as April. So pretty good. And again, thank you to Commissioner Schnell for releasing your staff in that way. So as far as the legislative update, we've had roughly 3 dozen bills that we've had to do fiscal notes on, just to talk about some of those. There are bills, and I may have talked about some of these, but there are bills to increase carjacking penalties. Basically, what we pictured is carjacking would become, we assumed that the commission would, because there's higher statutory maximums, that the commission would rank carjacking essentially one severity level higher than the corresponding robbery offense. And there's also mandatory minimums associated with those, and those are hard mandatories as it's written. Speaking of mandatory minimums, we talked about before 6 and 9/11 mandatory minimums. There's a bill to make that hard. So no waivers permitted for 6 and 9/11. That's probably our biggest ticket item as far as prison beds go. Although I should say, with respect to all prison bed bills, there's essentially a bit of a free ride effect for the legislature, because it takes multiple years for some of these prison beds to take effect. So, for example, there's a bill that would for 609-1095, which is repeat offenses. There's a repeat violent offender provision. There's a dangerous offender provision, and there's a career offender provision. And it's basically making those, as I understand it, it's a little bit confusing to me the way the bill's written, but as I understand it, it's making those mandatory commits. Well, most of them are commits now anyway, but it's making them mandatory commits, and it's requiring aggravated departures. Right now, it's just permitting aggravated departures. But the big change in that bill is that it is for all of those qualifying offenses, there's no longer going to be any supervised release. So they're going for the entire pronounced duration. Essentially, the most dangerous, repeat dangerous career offenders are going to serve the entire sentence in prison and then be released on the street with no supervision. But that's going to be a significant prison bed impact, and that wasn't even discussed in the Senate Judiciary yesterday. Even though that from a prison bed point of view, that's the most significant impact of the bill. A few bills would enhance penalties in different ways for fleeing a peace officer in a motor vehicle. That seems to be something that's captured the legislature's attention. Organized retail theft, there's a few versions of that that are floating out there. One, basically, if you're shoplifting, but you're doing it with the intent not just to use the merchandise, if you will. You're stealing a hat because you want the hat, but you're stealing a hat because you want to resell it, or you want to return it for cash or some kind of fraudulent activity. That falls under organized retail theft. There's also a version of that bill that would say if you get a trespass notice from a merchant and then you come back to that merchant with the intent to steal, that's burglary. So that's an interesting bill. Let's see, I think I talked about most of those. And then there are these, there are, as I said, marijuana bills out there that would not legalize marijuana, not decriminalize it any more than it's already decriminalized, but sort of create sort of an intermediate layer, possibility of gross misdemeanor treatment, which currently doesn't exist for marijuana. And then there is a bill that I think is going to be heard tomorrow on aiding and abetting felony murder, which is the outcome of a task force that I was on, the aiding and abetting felony murder task force. So essentially, it's requiring a little bit more for somebody who's aiding and abetting a felony murder. I could talk at length about this if you like, but basically requiring some kind of foreseeability that death was going to happen, not just, the getaway driver, was hoping to get some cash and then all of a sudden somebody dies and the getaway driver is on the hook for murder. With respect to commission specific bills, there is that bill that would require Senate confirmation is still sitting on the Senate floor. That has not been acted on by the Senate. The same is true of the bill that would make MSGC staff, other than myself, classified employees of the state. That's also sitting on the Senate floor. That bill is also going to be heard tomorrow by the House Crime Committee. So I'm happy about that. I'll be testifying in favor of that bill because that's a bill that you've taken a position on. And I think that does it for the legislative update. And then the third part of my report was, unless there are any questions about legislative action.
Anybody have a question?
Okay. One other thing I should have said, on the Senate side, there doesn't seem to be any action being taken on any of these bills. They're hearing the bills and then they're laying them over for possible inclusion in a future, presumably a future omnibus crime bill that will come out of the Senate. The final thing was with respect to meeting rooms. We are expecting, well, the Commissioner of Management and Budget has reported that state buildings will be fully open to the public later this month. So it was later this month.
April 22nd.
April. I'm sorry. So April. So we still have to figure out our April meeting room. We might impose on the commissioner's hospitality and try this room again. We did have some technical glitches, but I really like the fact that the camera follows the speaker around automatically. That's super nice. We don't have that in any other rooms. But again, we had some technical problems. I wasn't able to get on VPN and run the meeting, which can be a problem. That wasn't an issue at the Senate buildings. But this has free parking and public access, so it is a nice building.
I like that
Sure,
part.
but I mean, unless there's an objection, starting in May, we would go back to Lady Slipper, which I don't think some of you have even been to Lady Slipper, but that's a meeting room that's conveniently right across the hall from our staff offices. So that definitely wins it for staff convenience. But it's also a pretty good setup. There are microphones from the ceiling, and there's a camera, so hybrid meetings do work well. One bill I didn't talk about, it requires you to basically put all your meetings on YouTube, which is not a problem right now, but it will be a problem if and when we go back to just regular in-person meetings, because right now we sort of have to flow everything through technology because to make the hybrid meeting work. So it's not an issue to just press record and then everything that went through the technology gets put up on YouTube. So we are thinking that bill would require a cost because we'd have to buy some technology, just basically standalone stuff that would follow your faces around and record the meeting and put that on YouTube. And that may be something you want to do anyway. You may want to just in the interest of transparency, put meetings on YouTube, even if the legislature doesn't require it after, assuming there is an after COVID, after we go back to in-person meetings, which I guess I'm assuming we're going to do, but that decision obviously hasn't been made by you yet. And that concludes my report, Madam Chair.
Madam Chair,
Commissioner Knudsen?
maybe if we're going to stay here for another meeting, we could figure out a way where the last remote speaker doesn't stay on the gigantic screen staring at everybody in the room.
There you
You
are.
like your chambers, Judge Knudsen.
Oh, man.
I'm going to be asking you about your camera after the meeting, Judge Knudsen. You look pretty sharp there.
All right, any other questions or comments? If not, let's go ahead and move to the public input portion of the meeting.
All right, so members of the public, and I don't have my script, Madam Chair, because of the VPN issue, but I believe it goes something like this. So members of the public, in a minute, I'm going to unmute your microphones. I see there are not very many of you left. Let's see, so I'm going to unmute all your microphones if you don't want to make a comment. So it's going to become a two-way channel of communication. So we're going to be able to hear whatever's going on your end, members of the public. So if you don't want to make a comment, please immediately remute your microphones if you're able to do that. If you do want to make a comment, please state your name and the chair will call on you. So I'm now unmuting all your microphones. And Shauna, that will include you. So please remute quickly. All right. All right, your microphones are now unmuted. Please state your name if you wish to make a comment.
Michelle Hipsig.
All right, please go ahead.
Hi, thank you for allowing the public to participate in this meeting. It's been very informative, and I do appreciate the opportunity. I would like to speak on behalf of the point reduction proposal, and I would like to thank those who pointed out certain issues with it and concern to the public, as I find this to be very concerning because you see, I am a victim, and my grandson and my daughter were both a victim to a repeat offender. My grandson was left to die lying in the road, which he did die. My daughter suffered extensive medical, psychological injuries. And, you know, with repeat offenders, they're not there because they're law-abiding citizens. They don't have a high point system because they are law-abiding citizens. And unfortunately, most of them really don't care. I have not seen much effort on a lot of their parts of these repeat offenders. They continually just keep doing this. So to reduce the point system is honestly, from my perspective, a very insulting thing to the public, all of us as the victims, because you view it a lot, it looks good on paper, and it may look great on paper, but it looks a lot differently, and you have a whole different perspective when you see your loved one laying on the slab. This is, as far as I'm concerned, not acceptable approach to handling this. There are programs such as Prison Fellowship that supposedly does have increased rates of success. I don't know, I have not looked at it a lot, but there's a lot of these repeat offenders that just, as I said, the only thing that governs them is getting caught. And if you're going to lower that perspective, frankly, that puts the public, which is your constituents, who you're responsible to, at risk. And I am not supportive of that at all. Thank you.
Thank you very much for your comments today, and we really appreciate you providing your perspective on this issue. Are there any other comments from members of the commission? Or it looks like Nate. First, let's go to Commissioner Larkin and then Nate.
I took my headset off. Can you hear me all right?
We can.
Okay.
Yeah.
The last comment reminds me, you know, when we talked about meeting room and Nate mentioned the bill that's pending and the desire for transparency, I'd like to speak in favor of continuing to have hybrid meetings wherever we meet for two reasons. The first is I think it's apparent that the hybrid meeting allows greater transparency and greater public participation. I think, you know, we've seen over the past months, year, we get a lot more input from the public at the end of the hearing when it's easy enough for the public to do that from their home online. So I'd like to see that continue. The other thing is we do all as commissioners put a lot of time and effort into our role as commissioners. And there are some people who, in order to come over to St. Paul for a meeting, it ends up being their entire day because they've got, you know, a 1.5, a 2 hour, a 3 hour drive to get there. So I think it enables better participation. It I think widens the possibility for people wanting to serve on the commission if they're able to participate remotely. And I think the past 2 years have shown us that this works really well, and I don't see a downside to it except an occasional glitch, which maybe costs us a minute. But I think the benefits of the hybrid meeting, allowing members of the public to watch our meetings from their home, allowing members of the public to comment from their home, making it easier for people to serve as commissioners, and having a recording of what we've done that can then be viewed. I think all of those things outweigh any, you know, costs that are attendant to the purchase of some equipment to make it happen. So I think we should support any legislation that takes us in that direction.
All right, thank you. Nate, did you have a comment you want to make?
Yeah, Madam Chair, I just want to apologize to the commission. I just realized that, so last week I had COVID. I was back, like the first day back at work was the day I sent out the commission materials, and I neglected to include the public comments that we had received to that time. So we did have a number of public comments, and I failed to send those out to you. I apologize for that. Those will, I could send those out in next meeting materials unless you'd like to see them before that. But I mean, if I sent them out now, I could just sort of include them in the record of this month's meeting, so they would be available to the public because, you know, what I sent to you, I need to send it to the public as well, or I will just include them in the April meeting materials. But I apologize for my neglect in doing that. I just didn't think about it in sort of my COVID fog last week.
Commissioner Larkin.
Yeah, my preference would be to receive those now and have them posted on our website as part of today's record, so the public can see them and know that their comments were received and considered.
I was going to say the same thing. I think it's fine if you want to send those to us after the meeting and then include it in the.
Yeah, I don't know if I'll be able to do that today, but
yeah,
I will definitely do that tomorrow.
Tomorrow is great. Thank you, Nate.
Yeah.
All right. Any other issues for today that we need to discuss? All right. Thank you so much for, I think, what was a very good conversation today. I really appreciate everyone bringing your thoughts to the table. I think it was a great conversation for us and for the public, for others to hear. And Nate enjoyed it, so it must have been good, right? All right, so with that, if there's nothing else, then the meeting is adjourned, and I'll see you all next month.